Hi, I'm Mark Turner, a planning law partner and head of the Planning, Environmental, Energy and Regulatory team at Aaron & Partners, and I'm here today to answer some common questions about judicial review. Judicial review is the process whereby people can challenge the grant of a planning permission and other planning decisions, and it's very similar to a statutory challenge whereby an appeal decision can be challenged in the High Court. Essentially, the court isn't looking at the planning merits of the decision, but they'll be looking at whether the decision maker acted lawfully. For example, whether the decision maker took into account everything that it should have and disregarded all irrelevant matters. And if the court decides that the decision maker acted unlawfully, then it can quash the decision and send it back to the decision maker for redetermination. Judicial review can be used to challenge the grant of a planning permission by a local planning authority, either following a committee decision or the decision of a case officer. Judicial reviews are very similar to statutory challenges, which can be used to challenge the decision on an appeal, either a grant of permission or dismissal of an appeal, usually following a decision by a planning inspector. With a planning appeal, such as an appeal against the refusal by a local planning authority to grant planning permission, the appeal is made to the Secretary of State in England or the Welsh ministers in Wales, and the decision maker will effectively be deciding on the planning merits of the scheme and whether planning permission should be granted. Whereas with a judicial review or a statutory challenge in respect of an appeal decision, the court will be looking at the lawfulness of the case, so they won't be looking at the planning merits. They'll only be considering whether the decision was made lawfully. Yes, there is a very strict period following the grant of a planning permission or the making of another planning decision within which to challenge it. So for judicial reviews and statutory challenges, it's 6 weeks following the decision. So it's absolutely essential to get legal advice urgently if you are considering challenging a planning decision. There are a number of risks involved with judicial reviews and other High Court actions such as statutory challenges, including cost risk. So they are very expensive actions to bring and the losing party will have to pay the vast majority of the winner's costs. There's also uncertainty, so the court is always reluctant to interfere with a decision made by a local planning authority or an appeal authority. And there is also the fact that even if the court decides that the decision should be quashed and sent back to the decision maker for redetermination, that the decision maker then makes the same decision without the legal error that was identified by the court. Developers will have the chance to be involved in the High Court proceedings, albeit they don't have to be because the challenge is against the decision maker rather than the developer. It's often sensible for developers to be involved in the proceedings rather than leave it to the decision maker to defend the claim. And we often act for developers who are facing challenges to planning permissions that they've obtained. And it's always essential to get advice as early as possible in the process.